What counts as personal data? Direct identifiers, indirect identifiers, sensitive personal data, and how the identifiability test works in practice. Every obligation in the DPDP Act starts with one question: is the data you are holding personal data? Get it right, and you know exactly what applies to you. Get it wrong, and you either miss your obligations or waste resources protecting data that did not need it. This video answers that question clearly. The Act defines personal data in Section 2T, any data about an individual who is identifiable from that data. One word matters most here: not personal, not data. Identifiable, not identified in the past, identifiable now or in the future. Data that could identify someone when combined with other information that is already personal data today. 5 categories. Most businesses hold all 5. 1. Contact and identity data: names, phone numbers, email addresses, Aadhaar numbers, PAN. 2. Financial and transaction data: purchase history, payment records, bank account details. 3. Digital identifiers: IP addresses, device IDs, cookie identifiers. 4. Behavioral and location data: browsing history, GPS coordinates, app usage patterns. 5. Employment records: salary data, performance files, HR records. Some data falls outside the definition entirely. Truly anonymized data, where no re-identification is possible. Not personal data. Aggregate statistics, like total visitor counts. Not personal data. Data about deceased persons, not covered. But here is where businesses get it wrong. Pseudonymized data is still personal data. If you removed names from records but still hold the key that links them back to individuals, those records are personal data. Removing the name does not remove the obligation. Apply this test to any data point in your business. 3 questions. 1. Does this data relate to a living individual? 2. Can that individual be identified from this data, directly or in combination with anything else you hold? 3. Is identification possible using other data anyone could reasonably access? Yes to all 3. Personal data. The Act applies in full. Within personal data, there is a subset with higher obligations: sensitive personal data. The specific categories will be notified by the central government. Expected to include biometric data, health records, financial information, and government identity numbers like Aadhaar and PAN. If your business collects any of these, track government notifications closely. The obligations will exceed standard consent requirements. Start mapping these categories now before the notification is issued. A quick reference: a full name with a phone number, direct identifier, personal data, an IP address linked to a logged-in account, indirect identifier, still personal data. A cookie ID with no account link at all. Depends on whether other data you hold creates the link. Document your reasoning. Aggregate traffic counts, not personal data, an Aadhaar number, direct identifier, personal data, and sensitive. Same question every time. Is identification possible? 3 action steps from this video. 1. List every system that collects data from individuals. Website forms, your CRM, HR records, payment platform, support tickets. List them all. 2. Apply the identifiability test to each system. Can anyone be identified from what it holds? Document the answer. 3. Flag anything in a sensitive category: health data, financial records, biometric data, government IDs. Get ahead of this now. 3 takeaways. 1. The word is identifiable, not identified. If data can identify someone in the future, it is personal data today. 2. Pseudonymized data is still personal data if you hold the key. Only truly anonymized data falls outside the definition. 3. Sensitive personal data will carry higher obligations. Start mapping those categories in your business now. Next, Video 4, the data fiduciary, what that classification means and what it triggers.